In corporate mergers and acquisitions, a corporation's board of directors may enter into a merger agreement with another corporation's board of directors. Following the agreement, stockholders usually have the right to vote on the merger plan, and a certain percentage of stockholders must approve the transaction. In the case In re Volcano Corporation Stockholder Litigation, the Delaware Court of Chancery considered what standard of review applies to the acceptance of a first-step tender offer by a majority of fully informed, uncoerced, and disinterested stockholders. Volcano Corporation was a publicly traded Delaware corporation and the global leader in intravascular imaging for coronary and peripheral applications and physiology. In June of 2014, Connecticut Phillips, N.V., became interested in acquiring Volcano. 1 month later, after Volcano's stock closed at roughly $16 per share, Phillips made a non-binding indication of interest to acquire Volcano for $24 per share, subject to an 8-week period of exclusivity to perform due diligence. In response, Volcano's board met and retained Goldman Sachs as its financial advisor. Goldman then advised Phillips's financial advisor that its price would have to increase for Volcano to consider exclusivity. Phillips declined to increase its price and proceeded with due diligence. During due diligence, Volcano issued its earnings release and reduced its projected long-term growth rate, causing its stock price to plummet. A few months later, the board approved a merger, and Volcano and Phillips agreed to a two-step acquisition, that is, a tender offer followed by a cash-out merger for $18 per share. Phillips then commenced a tender offer to purchase Volcano's outstanding stock, and Volcano's board recommended that stockholders accept the offer. Ultimately, the tender offer closed with 89.1% of Volcano's outstanding shares being tendered. Subsequently, before the merger closed, 3 dissenting stockholders filed class action suits in Chancery Court against Volcano and Goldman to enjoin the merger, and the actions were consolidated into one. In the action, the stockholders argued that Volcano's board breached its fiduciary duties in approving the merger, and that Goldman aided and abetted the breaches. In response, both Volcano and Goldman moved to dismiss for failure to state a claim.